25 CR 111 is called the State of Texas versus Harlan Dreamist Briggs. That's your name, sir? And you were here with Miss Minaldi and the state's attorney. This is an initial appearance. As you know, you were charged with a state jail felony of burglary of a building, which carries with it up to 2 years in the state jail. Today, what do we do?
Judge, I'm still waiting on my tape request to be fulfilled.
What do you want to do?
I need 4 weeks, Judge.
You got it? Okay. We're resetting these for 4 weeks. And Jasmine Young, 25 CR 363 is now called Jasmine Young. Is that you, ma'am?
Yes.
Present with your attorney, and it's Ms. Minaldi, who is going to represent you. This is a third-degree felony of tampering or fabricating with physical evidence, which carries with it up to 10 years in prison if convicted today.
I need 4 weeks, Judge, for the media.
That's just kind of like you're stuck in that. 4 weeks.
Yeah.
4 weeks. 4 weeks.
Have to try.
Oh, we'll do an announcement in 4 weeks.
Yeah.
Good. Okay.
Thank
you. Look, the state will be so kind to help get all that information as we can best, which as we can, please.
I think we put the place on the desk. You go.
Yeah, get it. Is the file with that? Because I don't see the file.
Okay.
So I looked at it last night. I just.
Okay, I'm here. It was on your desk.
Yeah, it goes right. From the rare. All right. Earlier in this case, the defendant entered a plea of guilty to aggravated assault, a second-degree felony, and a pre-sentence report has been prepared. Have the parties had an opportunity to review it? And are there any corrections or changes to it?
Judge, I've received and reviewed it, and we don't have any changes from the judge.
And state.
Same, Your Honor.
All right, it will be made part of the record for all purposes. And the agreement here is a cap of 10 years imprisonment. So we are looking at two options on the second-degree felony. No less than 2 nor more than 10 years confinement in prison. Also, the defendant could be placed on deferred or unadjudicated probation.
Yes,
I don't believe regular probation
is
an option under law because of the circumstances of this case. All right. Mr. Lewis, you may go forward.
Judge, this situation, fortunately, it wasn't worse than what it was. Definitely. But it was a situation where my client has been dealing with some harassment and bullying, dealing with the complainant, her friends for a long time at this period. This confrontation here is pretty much her breaking point at that moment. It was totally out of character for her. Not something that, in normal regular circumstances, she would have acted in that way in any way. It was a situation where, and when I say prior bullying and harassing information, I'm talking about from people coming, breaking or shooting the windows at her home to, very severe or serious circumstances, is that these things have been going on, and actually have been even still dealing with some of it after this case happened, while she's been on bond, to the point of people associated with the complainant or either screen recording or whatever, sometimes docket, and would post these things on social media in an effort to taunt her while this case has been going on. And there was even a situation where she's had people try to confront her. Now, I will say my client and her actions since then, she's done everything she can on her end to try to avoid these situations at all costs. She had moved to a new location that is a safer place for her and her child. That's undisclosed as far as she knows, as far as people associated with the complainant. She haven't had any issues while she's on bond as far as attending court or doing anything of that nature, other than I believe she had one situation where when she was in the hospital having a child, she had to miss court, but they had medical issues at that time. She has a 4-month-old child this time to raise and take care of. And as you see in the PSI, she has, until the pregnancy, maintained a stable work history, as well as going to school to help try to further her career. So she is making positive changes for herself, or I won't even say changes, staying on that same track. So I believe her future is one that's definitely salvageable in this circumstance. I think there's plenty of vehicles available through the probation department that could help Ms. Money as far as move forward, as well as still be able to serve out any punishment or sentence that court deems necessary. There, I know there's restitution involved in this case that my client, through with her schooling and her career moving forward, I think she'll be able to take care of that and do what she can to make the plaintiff whole in that circumstance. There are other conditions, of course, that's available to the court, as well as county jail time or anything of that nature to satisfy any concern the court may have of her actually serving some time in jail if necessary. And I know as far as her version of everything, she talks about, concerning the car running her over or running them over. If the evidence doesn't totally support that, but of course, what she may have been thinking of going through some of her friends, at that time could have been it, but maybe not enough to rise to the self-defense claim that she could have maybe used that trial, liable to use that trial. So we are asking that the court seriously consider placing her on deferred adjudication. I think she's the type of candidate that will be able to make the most of that circumstance and will be able to be successful and move forward. Also, I would like to, she did want me to let people know she wanted the opportunity to address the court and let you know how she would, her plans for the future, as well as her being able to be, how she feels for it being able to be successful on the deferred judge.
Yeah.
I just want to let the court know that I take full accountability of what happened today. And I am very, I changed my life all the way around. I don't hang around the same people. I have a child now. I'm in school. Everything around me is positive now.
Did you have a child then on March 30th?
Yeah.
You didn't have any, were you pregnant then?
I got pregnant after.
Okay, go ahead.
And it was out in a kind of a hard situation, but I take full accountability of everything that happened that day. I wish everything was different. And I wish I could take it back, but it's you can't take it back. It happened. And I take accountability of what happened.
What caused you to act this way?
I want to say I was just at a breaking point, really, to the point where it was so much that happened to me, with these people. So it's like a breaking point thing. And I was kind of in the fear of my life, and they probably was in the fear of their life as well, too.
How were you in the fear of your life? Can you explain that? Because only one person was shot more than once, right?
At the time,
And it was you doing the shooting.
when it was going on, before the shooting happened, she was kind of in her vehicle trying to run me over. It was a thing like that. So I was basically not defending myself, but at the same time trying to protect myself and who I was with. And basically, I guess she was trying to protect herself, who she was with.
Okay. The police came out and investigated this, didn't they?
Basically.
Okay. So after their investigation, did they charge the other people with attempting to harm you in some way, attempting to kill you, or attempting to assault you with their car? No? Does that no?
No.
You have to speak out.
No, sir.
Why do you think that? Or did the police fail in their job, or do you think they investigated this thoroughly?
In my opinion,
Mm-hmm.
I really don't think that it was, because when they called me, I was actually I was out of town when they called me. But I told them when I came, when I was coming back, and they were supposed to came out and fully investigate with me to take my side on what happened that day, and they didn't.
Well, they investigated it and they did not elect to file charges against the other people who you say were attempting to harm or kill you
Mhm.
with a car.
Correct.
That, and you were defending yourself. Self-defense. That's what it seems that you're saying here. You're not admitting, you're saying that they were trying to harm you and you were defending yourself by protecting yourself with a firearm and shot somebody 3 times, right?
Yes, sir.
The right shoulder blade, left ankle, left forearm, and upper lip, sorry, 4 times. But upon their investigation of this, they did not charge the other people with anything victimizing you, just you,
Correct.
which this leads anybody reading this to believe, according to their investigation, you just lost your composure and decided to use a file, which was the wrong thing to do.
Was.
Well, you got to pay a price.
Hmm.
Okay, well, too many people come in here and there's always somebody else's fault. And
And I was.
you're taking responsibility for your actions,
Correct.
but you have a lot to lose here. This could have been up to 20 years in prison. You understand that? And you got a child,
Right.
and that you got to take care of, and a family that's, I guess you're growing.
Yes.
And and you don't have a criminal history. What, this isn't the first time somebody is before this court charged with a serious crime who believed that a lot of it had to do with being provoked. But yet words, threats, those things are just under the law aren't enough to get in a car, get a gun and shoot somebody 4 times. And the situation about you were defending yourself, truly, Mr. Lewis is a very wise man and he evaluates cases. And if he felt like there was something really to substantiate that,
Mhm.
we would be having a trial like we have 600 trials in this court. I mean, we try cases and we're not afraid to try cases to get the facts out, get the truth, get responsibility placed on the people who justly deserve the responsibility. And this is one of those things where I believe we have a misunderstanding, to say the least. But you got to have the strength of character just to move on and be the better person. Because what happened is at the worst, at the best for you is they dragged you down to their level, and then you pull the gun, and then you get in trouble. And but once again, nothing shows that there's nothing here that reflects you had to use that firearm to defend yourself. You were in imminent danger of death or serious bodily injury from being run over by a car. Nothing shows that. And if it were, we'd be here trying this case, and that would be a defense. But you accepted responsibility under these terms, under this set of circumstances, and there are no objections in this pre-sentence report?
No, sir.
Okay, and it's made a part of the record for all purposes. What says the state?
Judge, I do note one error in the PSI. When you look underneath the adult felony court history, the deadly conduct, which I am dismissing as part of this plea agreement, comes from the same date and offense. For some reason, there's a different date there. So that needs to be corrected to where it's March 30th of 2024.
Okay, so it was this other charge arose, I guess this is 24 CR 1105.
Right.
This arose from the same episode?
Yes, sir.
So the agreement is that indictment is going to be, which is a third-degree felony of deadly conduct, discharge of a firearm. That is going to be
It'll be dismissed, but that should be corrected for the purposes of the PSI and this particular clause number, Judge.
Okay.
All right, so second matter. I'm really shocked that no statements come from Miss Ford, the victim in this matter. I've had constant contact with her since the beginning of this case. She is adamantly opposed to Miss Moaning receiving probation. That is a discussion that Mr. Lewis and I had while we were negotiating the resolution of this matter. Of course, what she wants is the maximum, and she's in opposition with me about the plea bargain agreement that was made. She's made that very vocal to our office, including my chief, and emails and things of that nature, which is why I'm really shocked that A, that there aren't statements from her, and B, that she may not be present here today. That being said,
Okay, in the pre-sentence report that's been placed into evidence on that point, so the
Yes.
record is clear. Statements of interested persons, and the probation office is I always want as much information to make an informed choice. This states all attempts to contact the victim in this case have been unsuccessful. Any correspondence received prior to sentencing will be forwarded to the court as a memo, which it was not done. All attempts to contact law enforcement have been unsuccessful.
yeah, I don't know
I've
whatever.
never seen that. This is odd. I've never seen a lack of response to the probation's office requests for information, but it without it, this court. I know what you're saying about what the victim says, but when given an opportunity here in the where it needs to be, so the court can consider it, they refuse to talk.
So I'll be her voice because I do know what she has expressed to me. She is overwhelmingly disappointed in how this matter has been handled by law enforcement. She is adamant that Miss Moaning not receive probation. She and I have visibly seen the injuries that she suffered. The PSI is correct that they are serious bodily injuries. It's very difficult for her to even travel. She is a Houston resident, and the timeframes that we've been able to meet, it's quite a struggle for Miss Ford to even accomplish that. To say that when we deal with aggravated assaults with a deadly weapon, that we are merely inches or seconds away from dealing with a murder case.
Mm-hmm.
I saw that when I saw the injuries that were apparent with Miss Ford. So with that in mind, Judge, disappointed with the defendant's version, but Your Honor has already gone into the detail about that, so I won't highlight that. I will say that her lawyer is an excellent advocate. He has been working on this case throughout. Mr. Lewis brought to me, we're always on a first name basis, so I'll be professional and say Mr. Lewis brought me the arguments about the bullying. He brought me the evidence that he was tendered. I investigated those claims. I found no merit in it. Otherwise, you would see something different. It was only due to his advocacy that I capped the agreement at this to allow him to come into court to make the best argument for his client as far as the probation is concerned. But as I said, I'm disappointed with how she approaches this. She tries to appear as the victim, tries to minimize the situation here that was done. And it is not a situation that anybody in Beaumont would be proud about. The situation that occurs is a shooting that happens in the heart of the West End, right across from Parkdale Mall, at a time in which most people, much like a case we dealt with earlier in this courtroom, Judge, are at home and asleep. 1:30 in the morning, right outside of Fuma, Dubai. Just like she describes, this is more of a nightclub than anything else. And the criminal activity that takes place here with the amount of shootings and the injury that takes place is alarming to me. And that highlights what the probation office says, which is as the defendant appeared to take responsibility for actions occurring that night, the violence that was inflicted upon the victim and the community is alarming. The defendant appeared to not take into consideration during the offense how innocent bystanders could have been harmed or killed from her actions. That's why the other
You said
case
the
was
victim,
filed.
the defendant.
I apologize. You're correct. The defendant appeared to not take into consideration during the offense how innocent bystanders could have been harmed or killed. Judge, these are the kind of things that with the DA's office, when guns are involved, shootings occur and near death almost happens, we cannot agree to probation. I can appreciate that she's never been in trouble before, but I don't think she appreciates that we almost lost someone due to her actions. Stand by the cap that was offered. I suggest 10 years.
Go ahead. Anything further, Mr. Lewis?
Well, Judge, just one thing I would like to add is that in Ms. Moni's statement to the court, you know, main reason she wanted even to do that was to make sure you understood that she was taking full responsibility for her actions. In no way she's trying to minimize what happened out there. She doesn't understand how severe that circumstance was. And that doesn't change my opinion that if given the opportunity, I believe she could definitely be successful on probation, especially with the track she was already on and what she could continue to do, especially in raising her child. You know, this moment, especially now, is totally different where she has someone else, even beside herself, to totally live for and make decisions. So I still stand by that and ask that the court consider deferred in the situation.
All right. Some circumstances are a lot more difficult than others that the court has to deal with. And this is an agreement, but it still gives the court options on how to proceed. Among other things, the court tries to set a standard on similar behavior, how people are going to be dealing with similar behavior upon rulings of the court when they are put in a situation. They may not be paying attention, but the ones who do go, you know, somebody got in trouble and went to prison for this not long ago. I better not do this. If they're able to think coherently during the time. And nothing, if it were true that the defendant was was defending herself under the law, that should have been raised in a different setting, but it was not. It wasn't. And there are ways of dealing with self-defense as a defense, and it's not supported here. It does state, it doesn't say that, except for you, that somebody was trying to hit you with a vehicle and you were shooting to defend yourself from a vehicle that was being driven at you when you were just walking across the parking lot innocently. That's not in here. That's what you're saying, but it's not in this pre-sentence report that was prepared and is what the court can consider. What we do know is that this was a product of something that had earlier occurred that should have been dropped. It was something had happened before, and as they were leaving, and as the parties were leaving the club at 1:33 in the morning, where nothing really good happens, then you are shooting at this vehicle and the people in the vehicle, and somebody shot 4 times. Not just for that purpose, but this is a public place and there are probably other cars, and you're lucky 3 or 4 people didn't get shot by wild shots. It's just you can't handle issues like this in a way that is irresponsible. Now, what are you doing? Well, this was a club, right?
Yes, sir.
What are you doing it sells liquor?
Yes.
What are you doing in there with a gun? What are you doing in there with a firearm anyway? That shouldn't even be in there. this was very poor choices, and you're lucky that this person who was shot 4 times in the shoulder, left ankle, forearm, and upper lip. I don't know how that happened, that they weren't seriously injured. And others in the parking lot weren't injured. I mean, several people could have been harmed. We've got to, by our decisions and what goes on in this court, set standard for everyone. This, Mr. Lewis is asking for probation, and it's an option in this particular situation, but it's these circumstances that this court has a lot of problems with in believing that probation and deferred or unadjudicated probation in this case is the way to go. I mean, it was multiple shots fired, and this why just God's will is. I mean, you were intending to shoot this person. God's will prevented a murder from happening, where you would be looking at up to life in prison. And messages have to be sent. You can't just go into a shooting spree in a public place, and people also get harmed, and people are in harm's way, and you're going to get a free ride out of that, and it's, as it were, and get probation. I mean, it's just all irresponsible from the beginning to the end on this. And the difficult thing is that you got a family at home that needs you, and the district attorney's office is asking for 10 years in prison. And if I hear somebody, I hear a response. Anybody that responds while the court is talking will be held in contempt of court. I don't want that. That's 180 days in jail. Anybody want to say anything? Now, please be quiet. We're conducting business, or leave if you want to. You have freedom of speech. Go outside and speak, but don't interrupt this court. I can hear that. We all hear that. And she's taking this down, and what she hears as the court reporter, she takes down. And statements from the crowd don't count. Please follow the rules. Thank you. The court has to set an example. This is highly irresponsible. You shouldn't have had a firearm in the first place at that location. Anyway, I mean, that's prevents you from losing your composure, which I think it's obvious you did. But when you shoot somebody 4 times, there's only one purpose, and that's to kill somebody. I mean, you don't shoot somebody 4 times and think, oh, I'm just going to wing them. That's not it. And one of them is a shot in the mouth as well. You're lucky. This is not a life imprisonment case. All right. Your attorney has minimized it to 10 years and up to 10 years in prison. What this court is going to do is these are more difficult. Some decisions up here are far more difficult than others, and this is one of those. The court is going to find that you have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in your plea hearing to find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault with a deadly weapon. I now find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault with a deadly weapon. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. And the judgment shall reflect that a deadly weapon, namely a firearm, was used in the commission of this crime. Do you understand what has happened today, May? All right. you and others must make wiser choices when there's a firearm and there is a situation where people can lose their composure. You're lucky that it wasn't a murder case, but you can't be firing a weapon numerous times at a public place and not be held responsible. And there's nothing here that supports anything in this report, nothing that shows you were acting in self-defense or that there was a need for it. That's the order of the court. This other case is
I've sent the dismissal.
dismissed. Thank you. That is all. I need a pen. This.
Yes.
John Bacote, is that you, sir?
Yes, sir.
You're here with your attorney, Mr. Grove, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about July 6th, 2024 in Jefferson County, Texas, you operated a motor vehicle in a public place while intoxicated, and it was occupied, the vehicle was occupied by a passenger younger than 15 years of age. And it says 3 paragraphs. It looks like 3 children were younger than 15 years of age.
That's correct, Your Honor.
Okay, this is a state jail felony, which carries with it, if convicted, confinement of any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand, sir?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years. And you must serve, is it 30 days?
Yes, Your Honor, that's what's recommended. Yes.
And you've requested that on weekends.
Yes, sir.
Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal. You understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1, part of the record for all purposes. Without objection. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement, serve nothing further, and find that you today, Mr. Bacote, are feeling or entering your guilty plea voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony of operating a motor vehicle while intoxicated with a child under 15 years of age. I'm following this agreement. You were hereby sentenced to confinement in the state jail for 2 years. That is suspended. You are placed on regular probation for 5 years. There will be terms and conditions of probation, which are normal and customary. You must pay a fine of $500, and there's an order that you shall serve 30 days in the county jail. This begins at 6 o'clock, on or before 6 o'clock each Friday, and then they let you out on or before 6 o'clock Sunday. So you get credit for 2 days on each weekend. That's the way that works. When can you begin that?
Not this weekend, and that's the next weekend.
Yeah, what is the date? It will begin on Friday week.
That's gonna be
I think the 27th.
27th.
This begins on Friday, 6/27, June 27th of 25. Do you understand everything that has happened today, sir?
Yes, and when I go to turn myself, where do I go to do the weekends? Do I,
County
I
Jail.
mean, county jail, but do I go to the back where the police take you in?
I don't know where, I don't know.
I think
where-
I think that is where they go around the back there.
Do you know?
You go to where you go bond out. There's a parking lot over the side.
Sure, if he
No,
puts
I
it in
don't-
front of the jail, they can tell him where.
Right, yeah. you
They'll
but I think
route
it's in
you
the back,
and, in fact, we informed them they will be expecting you. They know,
Yes,
they just,
integral.
you just can't walk in and say, I need to go to the jail. They've got to have documentation that supports it, and we'll have that. So they'll know about you and
As you go in and look to the jail, it's over on your right, extreme right. And it's where attorneys go to visit, but not family visitation place.
okay. Anything else? Please see the probation officer. Good luck, sir.